Good afternoon, everyone, and welcome. We are so grateful that you all are here, and I just want to thank our panelists and our moderator for being here for our inaugural event, Contraception in the Convent, Cathedral, and Classroom. This is part of a series that we have just created at Alliance Defending Freedom. My name is Carrie Kupek. I'm an attorney and legal communications director for Alliance Defending Freedom. Alliance Defending Freedom is a nonprofit legal organization that advocates for the right of people to freely live out their faith. We have a number of offices here in the United States. We have offices in Mexico, India, Brussels, Vienna, Strasbourg, and Geneva. And our areas of focus, as many of you are aware, religious liberty, life, and family. We also do a lot of university speech work, free speech work, which I know a number of people haven't been aware of, and I think it's an interesting point of focus for us as well. And as you also are probably aware, we are very involved with the Supreme Court. Over the last few years, we've had a case every term that either has been directly ours or we've been closely involved in. And that was sort of the inspiration for today. I thought, we're involved so much in litigation at the Supreme Court, and these are culture-shaping and culture-directing cases. And why not put together a series where we have the experts themselves talk about these cases, the experts who have been in these battles for years, who have litigated the cases themselves, who have been directly involved in some way or another. I always like to hear from the people who have that real-life experience, who have been working with the clients, been at the Supreme Court, know what it's like on the ground, and so that's why we're here today. And speaking of experts, I'd like to introduce to you Matt Bowman, my colleague. He is senior counsel here at Alliance Defending Freedom. He's also a host of our new Alliance Defending Freedom podcast called Freedom Matters, which is a weekly podcast we put out offering commentary on legal and cultural events. We do a number of interviews, so I encourage you to check it out. I'm one of the hosts as well. And as I was saying, Matt is an expert when it comes to the Obamacare contraception mandate. He clerked for Justice Alito, then Judge Alito on the Third Circuit, so he has interesting insight on one of the Supreme Court justices on the bench today. He was the first in the country to secure an injunction against the Obamacare mandate for a Colorado family business, which in other words means he was the first to successfully block the mandate from applying to religious family businesses. He was part of the Hobby Lobby Conestoga Woods legal team. Matt also represents the March for Life, which, as you know, is the organization that puts out that phenomenal event every year in January, usually when it's snowing. It's the largest pro-life gathering in the world, and they are also fighting the mandate. What's interesting at March for Life is that they are not a religious organization, and they have been successful in winning against the mandate thus far, and they are the first to win on grounds of science and philosophy. So this is very significant. Previously, these victories have come as a result of religious freedom, exercise, and Matt secured a victory at the federal district court on the grounds of science, morals, and philosophy. So that's quite significant. And as you can imagine, the government is appealing that. And Matt is also part of our team here at Alliance Defending Freedom, fighting this mandate. And we have a lot of lawsuits, and currently we are winning them 70-19 in the court, which is very impressive. And so I think I've made it pretty obvious that Matt knows what he's talking about when it comes to this issue. So without further ado, I introduce you to Matt Bowman.
Thanks, everyone. Thanks for coming. We love to have you here. I'm going to get a bit of an overview. First, I'm going to push this timer button and get us going. Okay, I'm going to give a bit of an overview of how we got to where we are today. Now, where we are today is 2 weeks out from a Supreme Court argument, which will occur before 8 justices instead of 9. In the lead case is the Zubik case. So this is actually 7 different cases from around the country of nonprofit religious organizations being told by the Obama administration, you have to have a health plan that delivers to your employees items that include birth control, items that can destroy embryos at the earliest stage, and sterilization. And they're having to fight this all the way to the Supreme Court. But how did we get to where we are? And the answer that I'm going to focus on is maybe something that you were hoping to not think about for the next hour and a half, and that's politics, presidential politics in particular. But that is how we got where we are. But let me first, I'm going to give a brief introduction to our distinguished panel, and then I'm going to give my overview. So Professor Helen Alvarez, She is a professor of law at George Mason University School of Law. She publishes on matters concerning marriage, parenting, non-marital households, and First Amendment religion clauses. She's a consultant to the Pontifical Council of the Laity at the Vatican, an advisor to the U.S. Conference of Catholic Bishops, the founder of WomenSpeakForThemselves.com, and an ABC News consultant. She publishes regularly in news outlets including the New York Times, the Washington Post, the Huffington Post, USA Today, University of Chicago School of Divinity just published a piece of hers on the abortion case from last week. She speaks at academic and professional conferences in the United States. She cooperates with the Permanent Observer Mission of the Holy See at the United Nations. And she may or may not discuss George Mason's loss to St. Louis at the Atlantic 10 conference yesterday, but we'll leave that up to her. Catherine Seltzer is a reporter and producer for EWTN News Nightly. She's an international evening news program put on from a Catholic perspective. As founding news team member, she assisted with the St. John Paul II canonization coverage in Rome. She followed Pope Francis during his recent visit to the U.S. She reported on topics ranging from Supreme Court hearings to pro-life issues here in Washington, D.C. She graduated from Florida State University with a degree in advertising and previously worked at the Zimmerman Agency, where she assisted coordinating digital content for national brands. She will not be talking about Florida State's embarrassing loss to Virginia Tech yesterday evening. Greg Baylor, however, is going to keep us strictly on schedule so he can go watch Duke lose to Notre Dame again after this conference ends. Otherwise, Greg serves as senior counsel here at Alliance Defending Freedom, where he is the director of the religious schools team. He litigates cases to protect the rights of Christian educational institutions across the nation. Greg joined ADF in 2009. He's the religious liberty consultant to the Council for Christian Colleges and Universities. He also works to protect the First Amendment freedoms of students, faculty, and staff at public colleges and universities. He got his JD in 1990 at Duke University School of Law, where he graduated with high honors. He's admitted to the bar in Texas, the U.S. Supreme Court, and many federal courts. And Greg has 4 clients with Alliance Defending Freedom in these 7 cases at the U.S. Supreme Court for evangelical colleges from around the country. And they are there along with a whole host of religious organizations, church-related groups, even nuns, of course, the Little Sisters of the Poor. And they find themselves at the Supreme Court 6 years after the Affordable Care Act passed this month in the U.S. Congress, and President Obama signed it in late March. And when it passed, there was no contraception mandate in the Affordable Care Act. It's not in the text. In fact, 21 times prior to the Affordable Care Act, there had been an attempt to federally mandate that health insurance plans cover birth control and these early abortifacients and sterilization, and it never got out of committee. And it didn't happen in the Affordable Care Act either. There's a clause in there that says there will be women's preventive services, and it doesn't say what they are. And it leaves it, however, to the Secretary of Health and Human Services, who in turn relied on not even someone appointed by the executive branch, the Institute of Medicine, which is a private organization. Well, they decided, of course, to insert this mandate. But there are many mandates in Obamacare, as you know, and there are many of them that apply to every health plan. Of course, pre-existing conditions. You can't have plans discriminate against people because they have pre-existing conditions. You have the requirement that your plan will cover your kids up to age 26, dependent care. These are requirements that apply to every plan, and the regulations call these particularly significant protections because we're going to apply them to every plan. The Women's Preventive Services Mandate is not one of those particularly significant protections. It doesn't apply to every plan. It doesn't apply to the plans where the president said, if you like your plan, you can keep it. So we're not going to change it if it existed when this act passed in 2010. Instead, it was imposed on a subset of plans that aren't grandfathered. And so come on in, and there's food in the hallway, and there are some seats in the front. So the people coming in late, you might pick a seat in the front if you don't want to stand. So we had this mandate was created not even by bureaucrats, which itself would have been bad enough, right? It was created by kind of sub-private bureaucrats. And why did they mandate it? Well, they said, well, look, here's the theory. The theory of the mandate, how is this going to benefit people? It's not forcing people to use birth control or the morning after pill or the IUD or sterilization. So what's the theory? The theory is, well, if we cover it in the insurance, then more women might use it. And then, well, if they do, they might get pregnant less. And if they do, some of those pregnancies might avoid health complications or might avoid workplace inequality. That's the theory. And so they said, well, therefore it is for women who, quote, want it, unquote. Like that, the advancing of the government's interest only works for the women who want it. The problem that arose, of course, is that some employers objected. And this mandate, which developed in 2011, ran right into the 2012 presidential election cycle. And so in early 2012, there was an outcry from the public and even from some members in the center left, in the religious center left, that said, why are you imposing this on even church-related groups? There was an exemption created for churches themselves, and it was fairly narrow. And the theory of the exemption was, well, the mandate is only for women who want it, and people who work at churches, quote, likely oppose it anyway. If they're not going to use it, the government's interest isn't advanced, so we'll exempt them. But we're not exempting a lot of these religious groups who are now at the Supreme Court. There was an outcry, and what happened, it was an election year, the president decided we're going to punt the issue. We're going to not decide what to do with the Christian colleges, with the nuns. We're going to give them a, quote, safe harbor, which just is essentially was a temporary exemption for a couple of years. In the meantime, we will immediately force the families who are in business to cover these items, and then we will make it an election year issue that if you oppose those families in business, then you are engaging in a war on women. If you oppose a religious exemption for the families in business, you're engaging in a war on women. And then Sandra Fluck came out, and we had the whole 2012 election cycle defined by the war on women. And that summer, we at Alliance Defending Freedom were involved in some of the early cases, and that's when we got the first injunction on behalf of the Newland family, which runs an HVAC company out of Denver. And we got the court there said, the Religious Freedom Restoration Act overrides this requirement created by these like sub-bureaucrats. And then we went on to say, oh, okay, well now we have a Bible publishing company in Illinois, Tyndale House Publishers, and the Obama administration said, you have to cover these items too, and a judge down the street here in D.C. said, no, they don't. The Religious Freedom Restoration Act protects them. And we got to a point then where last year, we had to, it was 2 years ago, we had to bring a lawsuit on behalf of March for Life. They run the March for Life. It's a 5-person nonprofit organization dedicated to the sole purpose of protecting embryos from these items that they believe can destroy them and from abortions later in pregnancy. And the Obama administration said, okay, you're run by a woman, Jeannie Mancini. You employ women. You only hire people who oppose these items. You have to include these items in your health insurance plan. And even though this mandate only helps women who want it. We've already said that. We've already exempted churches because they likely don't want it. We know you don't want it. You work at March for Life. You still have to have it. And then a judge down the street in August decided, no, you don't. That doesn't make any sense at all. The only rationale for imposing this mandate to that extreme is because you're trying to suppress dissenters in society who actually disagree with these items. And that's where we are today. How is it that in the Hobby Lobby case, in the case of the co-plaintiffs, Conestoga Wood Specialties, the Mennonites from Lancaster County who represent us, who we represent at Alliance Defending Freedom, how is it that they won, but that the colleges and the nuns have to go to the Supreme Court in 2 weeks? Well, that's where we are today because of this politically motivated requirement. And we're going to have a very distinguished panel talk to you about not only the legal but the cultural implications and maybe even the political implications of this debate. So I'm going to step over to have a conversation with them right now. So I'm going to be switching microphones. So your microphone.
While the Roots band plays.
Push the button when it turns green. Your microphone is on. Okay. So Professor Alvarez, tell us a little bit about you've had a role in these cases. You've written some briefs. Tell us about. Give us a little introduction on your perspective on these cases and what your involvement has been. Just are you good?
I'm pressing it.
Okay, let's trade.
And it goes from yellow to red. Thank you. Okay. So I teach at George Mason both family law and law and religion. And I came to family law in particular because I had spent some years, after I was a litigator, I worked in pro-life for the U.S. bishops and spent a great amount of time with post-aborted women. And I realized I better get into the demand side of abortion. You know, what had driven them to a point that they didn't want to be. So I think a lot about the interplay of law and policy and the sexual ethic that sort of immiserates women in a current marketplace where sex, you can tell I'm George Mason, right, the law and econ, where sex has become very inexpensive, where, and it's the price of a relationship, and women are in a prisoner's dilemma, and they're not, the government isn't doing anything to help it. In fact, I think they're making it worse. I realized that one of the last places that was still trying to articulate in a rational way why this sexual ethic was problematic and using law and econ data and sociological and psychological data were the religious outlets, which were trying to preserve a particular sexual ethic, but the government was now trying to silence their speech and remove them from the public square. So that meant I had to develop a capacity, in addition to family law, in law and religion. So that's what I did. And for the last, so I've been teaching family law for 16, 17 years. I've been teaching law and religion for about 8 and writing scholarship in it. So what I found the day that I saw the Institute of Medicine report come out, August 1, 2011, and then saw the regs come out in 2012, was that I looked at their case and I thought, wow, this is really weak. I mean, it's just empirically so tiny. The footnotes, I'm so highly familiar with the data in this area that I went and read all the data in all the footnotes, which are very few in the government report. And I said, they really don't have the data to claim what they're claiming. And I began to write about it. I then put out the day that Congress had a hearing on this, and very foolishly, Congress had a first panel with all men and a second panel with a few women to discuss contraception. Good move. And that day I kept getting all these calls that asked, you know, where were you? Well, I had been scheduled and they replaced me with a man. So I wrote a letter publicly and circulated it to about 20, 30 friends. Another friend of mine who's a religious freedom lawyer cooperated with me. And we went from 30 signatures to about 44,000 without any advertising. Women, there was a market for this idea. What's the idea? Number one, the government keeps talking about sexual expression without kids as sort of the centerpiece of women's freedom, the thing they're really willing to commit themselves to in a huge way. And number two, they're willing to push out of the public square and public discourse dissenters from that. But actually, women actually practice religion more than men in the United States, for the most part. They really support religious freedom very strongly. And they don't necessarily think the sexual ethic that the government is promoting is a good idea. So very briefly, I looked at all the data the government put out and the data they ignored. And I'll talk about this more later, but they're trying to argue this, more women will use it. It will drive down unintended pregnancy rates. It will drive down abortion rates. It will improve women's health, and it will promote equality in healthcare costs. And it was great fun and very tedious tracing the source of the little figures that they were using to their origins. So it turns out that the populations that the government has targeted with the most free or subsidized contraception actually have increased their unintended pregnancy rates from the late 70s to today, from 34% to 51%. The abortion rate, while it's been going down recently, went up as Planned Parenthood and others who have done economic analyses show. Janet Yellen has the most famous piece on it in the 1996 Quarterly Journal of Economics about why the phenomenon of risk compensation will drive up risky behaviors when people think they're insured against, which is why we have more unintended pregnancies, more abortions, and more out-of-wedlock births, not less. And what was really fascinating was their claims about health, which left out several things. Number one, the U.S. Preventive Services Task Force, which has put into place every single preventive health recommendation from that IOM report, the sub-bureaucrats report, as Matt calls it. They have not included contraception yet, 5 years after that report was made. I think part of it may be the massive lawsuits against Big Pharma on this, maybe the WHO's worrying about some hormones being carcinogenic, and other side effects that HHS, in a recent request for proposal, talked about women experiencing. HHS says 36% of American women who are obese really shouldn't use hormonal stuff, and nor should 18% who are smoking. So I'm not shocked that Preventive Services Task Force has not adopted this, but it sure does undercut the government's case, which seems logical on its face, right? What is true for one woman vis-a-vis contraception should be true for a large cohort. But as Janet Yellen points out, there's other things that come into play here. So I'll stop there. Thank you.
Okay, and we'll hear more from you in a few moments. Greg, tell us about your clients and about your experience defending religious freedom for colleges, universities, and what perspective you bring to this particular case because of that experience.
Well, Matt gave a very fine introduction to the case and also to my role in it, but there was one mistake that I feel compelled to correct. Matt said that I had 4 clients in the Supreme Court. I actually have 5, which happens to be the number of national championships that Duke has won. As Matt mentioned, I have the privilege of serving as the director of ADF Center for Religious Schools. And although I did not attend religious schools, I've come to love them. And one of the things that impresses me about these institutions of higher education is they strive very hard to integrate their religious convictions into every aspect of their operations. They're not just secular schools with chapel and a mandatory Bible class. They really believe that it is possible, and they show that it's possible, to integrate Christian belief into every area of their institutional life. So when the Obamacare mandate came out and forced them to include drugs and devices that they had moral objections to, they were understandably upset because their health plans are a manifestation of their religious convictions. Their health plans reflect their religious beliefs about marriage and about sexuality. Now, all of my clients happen to be Protestant institutions that don't object on theological grounds to contraception writ broadly, but they are pro-life, and they manifest their pro-life beliefs in a lot of different ways, including the health plans that they offer to their employees and their students. So their objection is to the 4 out of the 20 FDA-approved contraceptives that can and do prevent implantation of a very young human being in the uterine wall and thus cause the death of that institution. So they didn't want to facilitate evil. The other thing that really upset them was that the exemption didn't include them. They worked very hard to make themselves serious religious organizations, and the government was saying, well, churches are religious, but not you. You're not religious enough. And I think that actually angered them. They were insulted by that. They believed that they were religious enough such that they should get the same exemption from the mandate that churches did. So I was part of a legal team that filed 6 lawsuits on behalf of educational institutions around the country. And we had great success at the beginning. Some of it was a little bit touch and go for a while there. We were asking for injunctions, preliminary injunctions from these district court judges. And we had a hard deadline coming up. These health plans tend to be like 12-month deals, and the mandate, just the way that the government did it, was set to kick in at the beginning of a plan year. So I remember Anna Hayes and I, my former legal assistant, were waiting for these courts to issue these injunctions so that we didn't have to go ask for an emergency injunction from the courts of appeals.
At Christmas time.
At Christmas time, yeah. This was like December 23 is when these injunctions are coming in. It was really something. But the point is, we were very successful in the district courts, which was great. And then we move up, the government appeals all these losses, and our side starts to lose. We lose and lose and lose. I did something that certainly was unique for me and unusual for most lawyers. Arguments before the courts of appeals are relatively rare things, even for litigators, and certainly the experience that I had doing 3 in 9 days and 4 in 22 days in November and December of 2015 was really something else. And it was good that I was arguing the same thing over and over, but we were concerned about the composition of our panels, and that concern turned out to be accurate. We lost 3 of the 4 cases that we appealed, that the government appealed, actually, to the courts of appeals. And that's what made it necessary for us and all of the others to go up to the Supreme Court. Our one victory, which was on behalf of Dordt College and Cornerstone University in the 8th Circuit, is what created the circuit split. All of the courts had ruled against the good guys, as it were, and it was that dissenting view, essentially, where the court got it right, in my judgment, I think made it all the more necessary for the court to take this case. And I'm privileged to be part of the team that's representing 5 petitioners at the Supreme Court. Thank you.
Well, it's a good thing we don't have 6, because I don't think there'll be a 6 national championship this year, Greg. But Catherine, we've been talking about this in the public discourse for 4 or 5 years now, and yet it's a Supreme Court case. It's back in the news. What is the approach that the public is taking on this issue? Are they paying much attention to it at all? And what do you see from the front lines of the reporting?
In regards to the public media taking it on, I think those stories are easy to be missed, but this is something of utmost importance to our news agenda. So as you mentioned, I'm a reporter for EWTN News Nightly. We are an international evening news program from a Catholic perspective. For those of you not familiar with EWTN, we are the largest religious media network. And the program I work on specifically is news and analysis, and we have been following this case since the plaintiffs were in the lower courts. This is a case that is an intersection of 2 areas of great importance to us, our pro-life views and religious liberty. So while our news program does not have a conservative or liberal agenda, our mission is in line with the teachings of the Catholic Church. We remain objective as reporters, but we are unapologetic in our stance against contraception. And in full disclosure, I should state that our network, EWTN, does have a case against the same mandate. Last month, the 11th Circuit U.S. Court of Appeals did rule against our network, but we are given shelter until the Supreme Court rules in Zubik versus Burwell. And then, depending on how they rule, our network, our nonprofit, may be fined $35,000 per day. I think in regards to the public opinion and how this has been carried, the public opinion seems to be these religious groups just need to bite the bullet and comply. What's going on? They were given an accommodation. Isn't that a resolution? Whereas we, want to highlight the stories, no, it is not a resolution. The U.S. bishops have been very vocal on that, saying that they don't address, there's a very narrow definition in regards to a religious group. EWTN, founded by a Franciscan nun, we're not given exemption. Our whole mission is to share the teachings of the Catholic Church. I'm interested in this case for, a number of reasons. I am a big avid news watcher, and I did study advertising, so it's really interesting to see the narrative that other media networks take. And I'm not one to think that secular networks are the big bad media. I think there are a lot of hardworking, smart, intelligent, good-intentioned journalists out there. But I think in the daily grind of things of being a reporter, they grasp onto low-hanging fruit, and they grasp onto stories that are provided to them by, say, Planned Parenthood, with women saying, I do believe in contraception, I do believe my employer should cover that. So we want to offer the alternative stories. And also, as a woman myself, I don't believe that contraception is healthcare. As a millennial, I'm nervous about the religious landscape. And one quote that just came to mind as I was preparing and kind of gathering my thoughts for this was from the Cardinal Francis George of Chicago, and he's quoted as saying, I expect to die in my bed, my successor will die in prison, and his successor will die a martyr in the public square. This case is a fight to live out our faith in the public square, and we all need to be paying attention to it.
Catherine, you mentioned something that Helen also touched on, and I wonder if we could talk about it. It's this idea that, well, because it's said that women are for contraception, then they must also naturally, therefore, be in favor of a mandate of it. And there's 2 separate things, right? Someone could be not against contraception, but still not want to force people to buy it for other people. And someone could be for freedom and contraception. And I wonder if you and Helen have more thoughts about, as Helen mentioned, women tend to be more religious than men across the board. Is that a conclusion that we're jumping to too quickly, that just because people have disagreements about birth control or even these items that can be early abortifacients, that it means that they're in favor of forcing some people to violate their faith about it?
Yes, absolutely. Hitting on this assumption that, well, of course, this is good for women, let's go on this. And it kind of plays into that war on women rhetoric, right? Like, we have to, if you are not for contraception, then you are against women. Well, you could argue that contraception is a war against a woman's body. And there are many examples of women out there who are against it, and that's why Ms. Alvarez's work with Women Speak for Themselves is so important, to offer those stories of women who speak differently.
Just a couple of things. I haven't seen the polls lately. I remember paying attention to them years ago. By the way, I'm on hour 16 of food poisoning, so excuse my low intensity here. I'm kind of, Anyway, I haven't seen polls lately on this, but there were quite a few of them that said, listen, really, most women use contraception. Who doesn't want something free? But they also would like to respect religious freedom. I mean, I think that's not an uncommon. The rhetoric got really ratcheted up. Matt referred to politics. It became a huge part of the 2012 electoral campaign. The group Women Speak for Themselves, and, we've got a website, and we're going to be working with the Little Sisters on March 23rd at all the various houses around the country to show support. These women are like, listen, all I'm saying is that there's another view. I'm just saying it's not for everybody. I'm saying I had a bad health experience. I'm saying it changed the context and the fabric of my sex or dating or marriage. All I'm saying is no cheerleading. Why is the government getting on the cheerleading side of this? So it's a very modest, interposition here. It's not slamming everything and saying it should be made illegal. It's simply, why can't we have both religious freedom? And the vast majority of firms will cover it, some will not. It's pretty cheap. Why can't we rest at that level is the feeling of, I think, a large number of women, but I haven't seen it polled recently.
Do you think the resistance to there being another view is that it legitimizes the other view? So in other words, if you have these, I guess, subcultures of weird Christians who actually believe in medicine or fertility regulation that doesn't use artificial hormones, or actually believe in healthcare that adheres to the Hippocratic Oath, then that delegitimizes the kind of modern progressive view. Is that maybe part of it?
Right. Some of you might be aware, although I'm sure it's not widespread, that within both Catholic and Protestant cohorts of women around the United States, there really are a variety of opinions on this. And but the Catholic Church in particular, and evangelicals in particular, have a reputation as being sort of yesterday's news when it comes to sex, dating, marriage, parenting. They just do. And those of us who are working to overturn that are trying to bring forth, what can we do? I mean, bring forth the voices of individual women who talk about paths of freedom, paths of happiness that involve something different. And I think the epitome of the sort of expression of the government's position here, you may or may not have remembered when Colorado was opening its exchanges, it put out those postcards that had a girl saying, I'm so excited I can get free birth control. He's so hot, I hope he's as easy to get as the birth control. And it was like, really, like, okay, some people may like that. It seems really odd coming out of the government, right? With a 41% out of wedlock birth rate as the #1 predictor of poverty, it just seems odd. And what we're saying is back off. Just that there's these other opinions, let them both exist. Don't silence public institutions, public discourse that have another way that is sort of proved out. I often think of, in the Yoder case where the Supreme Court looked at the religious freedom of the Amish. It went and it looked at stories, it looks at experts, it looked at data about how their lives were lived. Well, I wish they'd do the same thing here and talk about how the lives regarding freedom, happiness, as women, as single women, as married women, et cetera, are lived in these traditions that the government seems very willing to characterize as backwards.
Greg, those traditions include some really amazing stories, and I'd like you maybe to tell at least one of them. Geneva College comes to mind of their role in promoting racial equality in America, but then also why don't those stories seem to catch on, or how can we help people recognize the importance of core religious values to institutions in our country and then the government not stamping those out?
Yeah, Geneva College was founded in the 19th century, and its motto is pro Christo, pro patria, for Christ and for country. And they put those in that order on purpose, because they believe that their obligation to follow God is superior to their obligation to follow the state. And they believe, as Martin Luther King did and others, that there are laws that require you to do evil and that you have a just reason to not obey those laws. And this is not the first time in the context of this HHS mandate that Geneva College has done that. They were part of the abolitionist movement in the mid-19th century, and slaves were escaping to the north via, in some cases, via the Underground Railroad, and Geneva College was a stop on the Underground Railroad. This was their participation, their harboring of slaves. The president of the college kept escaped slaves in his house. Geneva students accompanied with guns escaped slaves on their way to Canada to safety and to freedom. But they were in violation of the Fugitive Slave Act doing this. But they thought that being for Christ was more important than being for the government. I think the perception now is that religious liberty is just special pleading. It's just let us do what we want and let us avoid laws that apply to everybody else. And that's not really the right way to characterize it, nor has it been the way we've characterized it throughout American history. Since the beginning of the Republic, we've accommodated those, for example, who don't want to swear oaths. We've accommodated those who don't want to serve in the military. So it's not unprecedented to respect religious freedom. And I think it's particularly important here when the other side of it, the case for it, is so flimsy.
Well, one example I've seen recently, it's not exactly religious freedom, but we've seen a claim of conscience in our public discussion in the last week of news. And that's from Tim Cook of Apple, who says, not just as a legal matter, but as an ethical matter, I don't want to be conscripted into the surveillance state. And he's saying it on behalf of a corporation, which is saying I shouldn't be forced by the federal government to do something that not just I believe is illegal, but is wrong. And I wonder if there's a bridge there for people to realize, okay, even if you're not religious, maybe you don't want the government taking sides, as Helen said, and suppressing one ethical perspective. Do you think that might be an avenue to sort of wake people up to the requests of a group like Geneva College?
Well, I sure hope so, and I think it's always helpful for us to draw analogies to other situations that people might find more palatable to them. We talk about this all the time in the free speech context. We believe in freedom of expression even if we don't agree with that expression. I think that principle ought to transfer over to these other contexts, including the religious one. We're not asking for the government to support our view. We're not asking for the government to endorse our view or to force it upon other people. We're just asking for the space to live out our religious views. The Constitution has been interpreted to protect that, and it should be in this case as well.
Catherine, what arguments, if any, in this debate resonate with millennials? We've covered a lot of different issues, but I'm interested in your perspective as the millennial on the panel. Help us with that.
Something that has, as a millennial, that has caught my attention is I'm legitimately nervous for the future. If, depending on how the ruling goes with this case, will nonprofits have to close? Will Catholic charities have to close? Orphanages, schools, organizations that do such good work. I don't want to live in a future that doesn't have those organizations helping out. And while the church doors won't close, all the good work that these religious organizations very well may do that. I'm still young. I still have a lot of life to live, and we'll see how the future goes in this country. But I'm nervous if it is without the religious organizations.
Helen.
I had a thought. There's a couple of cases that I've been thinking of lately. One, do you remember the Little Pink House, the Kelo eminent domain case? They were going to bulldoze a house in Fort Trumbull, Connecticut, in order to put up the usual, a Gap and Ann Taylor and a Pfizer chemical employer, a Starbucks too. And anyway, the Little Pink House lost at the Supreme Court, and Connecticut immediately withdrew. And when I consider that with the flick of his wrist, the president could undo that, and Catherine's reflection on how kind of draconian this would be to think about these institutions under such a pall. The other is the Smith case, the 1990 case where Justice Scalia reread free exercise, but it was about peyote for Native American tribes. And after they lost at the Supreme Court, an exemption was put in the law. Like, okay, we push the principle, we don't want to go that far. And partly because that exemption was put in the law was why the next group that wanted to use, was it Huasca, a certain tea, got to use it in the Uniao case. So it's one thought. The other is, I know a lot of people are thinking, oh my goodness, Little Sisters or Geneva College, Little Sisters in particular, we're talking about you communicating with the government in a way that allows them to attach this kind of coverage to your either third-party administrator, healthcare plan, or your healthcare company that you contract with. And I mean, what's the big deal? And again, there's several things. One is you are still forcing this institution to be something else. They are no longer, something different out there. And it's okay to be different out there because they have valid, factual, empirical goods that come out of it. There's just no reason. I'm so struck by the government's attachment to that. I mean, they could have contracepted every, woman and child in America for what they've spent taking these cases up and down the courts. And I'm struck by their virulence in it. I mean, part of it is if you look at the constitutional law on sexual expression, whether it's Lawrence or Obergefell or the Casey opinion in particular, you see that there's a strong attachment to it as an American constitutional value. But they're not looking at the facts. They've gotten carried away with that as an ideology versus what's really happening on the ground.
Greg, we mentioned it already, but let's tackle it head on. Why isn't the government right that your clients are just being obstinate in refusing to fill out a form that would otherwise effectively accommodate them?
The best way to think about what's going on here is the government has two ways that you can comply with the mandate. There's the first way, which is to include it within the four corners of your health plan and pay for it. What's at stake in this case is method number two. It's not an opt-out or an accommodation. It's a method of complying. You do the things that the government makes you do. You are complying with the mandate, not getting out of it. The role of these employers is indispensable in the provision of the devices and drugs to which they object. It can't be done without them. And for the government to argue that they're playing no role whatsoever, that all they have to do is fill out a piece of paper, that they're objecting to object, those are just factually incorrect. It is the employer's health plan that is hijacked by the government. It is necessary for the employer to offer a health plan in the first place as the delivery vehicle for the drugs to which they object. In invoking, in complying with, in following this method number two, they have to complete paperwork that is necessary for the insurer or for the third-party administrator to provide the things to which they object. It is a normal application of moral reasoning to say, I object to doing something that will cause something evil to happen. And that's their objection to it, is they don't want to be part of this scheme. It's not just raising their hand and opting out. They are active participants in it. And what's really, I think, among the many offensive things about this whole litigation is that currently the government is saying, you know what, your moral analysis, your religious analysis of your role and whether it's wrong or right is wrong. You're being too hypersensitive ethically, and therefore you should lose. Now, they're trying to put it in a legal box, but in essence, that's what they're trying to do, is to say you're wrong about your own analysis of whether your behavior, your role is moral or immoral.
Now, how do you respond, again, as devil's advocate, to the idea that, oh, well, you're essentially saying that if someone was a conscientious objector to war, he wouldn't even be required to tell the government that he objects or something like that so they could find somebody else?
The analogy breaks down pretty quickly. Like I said before, these employers don't object to objecting. What they do object to is being involved. The analogy is not a conscientious objector saying, I can't go to war. The analogy would be if the person says, I can't go to war, and then the government says, fine, if you don't want to go to war, you personally have to go out and find your substitute. And I think it would be reasonable for a person to object in that circumstance, and that's the analogy that's far closer to what we have in this case.
So you'd have to go out, and it's the involvement, I think, that is the crux of it. They're still involved. And what does it say about a government that can sort of, it's almost as if they believe in their own regulatory power, that when we regulate, we create reality. And so by saying you're not involved, you're not. By saying it's not in your plan, it's not, even though it is. It looks like it's in your plan. It functions like it's in your plan. It goes to the people who are in the plan, but it's not really in the plan. Isn't that, there's something weird about a government who believes itself when it says that?
It's like, who do you believe? Your lion eyes or me? And, the government says it's them that you should believe. I mean, you know, their whole sense of what is happening is just inaccurate, and they have to mischaracterize what we're saying in order to win. If you read their briefs, they're not really responding to what we've said. They're creating a straw man that we're objecting to objecting or something like that and attacking that because they can't deny the reality. And they are, as I said before, trying to second guess our religious analysis, which is totally out of bounds.
And what would be the point of totally exempting churches if the accommodation were total exemption? I mean, the fact that there are two categories, the total exemption and the accommodation, sort of belies the idea the accommodation isn't really an exemption.
Well, they are conceding that complying with method 2 is a burden on religious exercise. They're conceding that because they've pointed to churches and say, you don't have to do that. You don't have to do anything. You're just exempt. And I find it interesting, too, that the government's behavior towards the employees of employers who are exempt. There are millions of these. There are millions of women who work for employers that have so-called grandfathered health plans, which don't need to comply with the mandate. There are hundreds of thousands of women who work for churches and such. What has the government done for those women? How has it accommodated their alleged need for contraception? It has done absolutely nothing. So when the government turns around and says it's necessary for Geneva College to allow its health plans to be used as delivery mechanisms for abortifacients, it's very difficult to square that demand with how they've behaved in other contexts.
Well, we are going to let all of you ask some questions to this panel now, and Carrie is going to you're going to ask the first question. You get the moderator's privilege.
Before I ask my question, I just want to encourage you all, I want to make this as interactive as possible. Ask legal questions, ask meaty questions, ask whatever question you want to ask. That's the purpose of these things. I want this to be a dialogue and a conversation. So my question is, this is to Helen and to Greg, of the briefs that you've read, obviously from the government and from the various parties before the court, have there been any arguments in particular that have struck you for whatever reason it may be? And the second part of my question is, what do you think we can expect from the Supreme Court justices? What kind of questions are we going to see at oral arguments?
Several things have struck me. One, I think the public might be really receptive to the government's idea, sadly, I think, that, you know, religions are saying they're burdened, but the burden just looks so attenuated. We're not asking them to swallow or implant anything. And I think that's going to be, and the government's been pushing that a great deal in the cases. I think it will have, it's attractive to the public. What the public does not realize is the Supreme Court has decisions, Thomas Review Board and now Hobby Lobby, that says it's not for the government to decide when moral cooperation is a violation of your conscience and when it's not. We just don't get into that, or else we're going to find ourselves digging around in religions, and we're not expert to pronounce on that. And then there's this thing called the Establishment Clause, so we cannot. On the other side, I think it's really interesting. A new piece of data came out. This is just because it sheds light on my area. There was a sociological look at, I think it's 28 states that had their own contraception mandates in the state. And I think I've seen it cited in quite a few briefs that showed that there was no reduction in unintended pregnancy or abortion in those states. I think, again, that's an interesting piece of data, especially because it's highly current and it goes to the heart of what the government says it's hoping for here. So those two things struck me out of the briefs.
You know, one of the things that struck me is that the government's entire argument, at least on the compelling interest side of the analysis, there's a certain number of questions the court needs to answer. How burdened is the religious exercise? And if it is burdened, has the government justified that burden? Has it shown that there's a compelling interest? Is there some other way that the government can accomplish its objective? We have offered alternative ways for the government to accomplish its objective. It is false when the government or anyone else on its side says that what we want is for our employees never to have access to contraceptives or abortifacients. That is absolutely not true. We've identified in our briefs from the very beginning the various alternative ways that the government can do this that don't involve us. But their response to that is no. There must be no administrative hurdles whatsoever. We responded and said, you know, one of the other ways that this can be done is to make contraceptive-only plans available on the exchanges. Now, in every other context, the government says the exchanges are awesome. They're really great. And they've spent billions of dollars making them user-friendly. And you know, frankly, things are better than when healthcare.gov first rolled out. And so that side of their mouth, they say the exchanges are great. But on the other side of their mouth, they say the exchanges are just totally unacceptable place for an alternative way of getting contraceptives in the hands of women who work for objecting employers. It's a dramatic inconsistency that they really haven't been able to explain. And I do hope that the court asks them about that.
All right. The microphone is being passed to Jonathan.
I'm Jonathan Embody with Christian Medical Association. It's primarily for Dr. Alvarez. And I wondered, can you think of other instances where the U.S. government in domestic policy is so aggressively promoting, discouraging childbirth? And what have we learned from other countries about some of the economic and social results when the government does that?
You know, I'm not sure I would say, are they discouraging childbirth? They're discouraging pregnancy that you don't wish. They're discouraging, to some extent, pregnancy outside of marriage, although they're very quiet once a person is in their 20s. So there was some activity vis-a-vis the out-of-wedlock birth rate, which women in their 20s picked up such speed in the 1990s that they've completely outpaced the decline in out-of-wedlock pregnancy among teens. What's interesting is that you go into, whether it's the White House Office of Women and Girls or HHS or NIH or CDC, and you look at their reports, and it's all very cheerful about being healthy in order to welcome children, right? Because that's the role of a governmental voice as well, to try and promote health in that area. But here, it's more about just putting adult interests at the front door. And to the extent that adult interests need to be accommodated, then we will either just ignore or turn our back on the interests of the children. Frankly, it's a theme in family law, and I could go on about that more length than you'd ever want to hear. It's just a theme that adults come first. And in particular, in our constitutional law in this arena, that adult sexual expression has a very, very important spot. And therefore, contraception, which Sandra O'Connor wrote that in the Casey decision, is necessary to make sure that, I think as she used a euphemism, that unplanned activity does not result in a child. So it's not so much, I think, anti-child as it is pro-adult freedom of choice.
Hi, this is Irina Grossu from Family Research Council. I have a question for the whole panel. The first is, I don't think what the public isn't understanding is that this is no accommodation, that really a company's no triggers the government stepping in or a third-party administrator stepping in and completing the task, but it requires the employer's objection. And so my first question is, how do we make this clear to people that this is not an accommodation? And the second question is, in other cases, such as people who are against blood transfusions, or you mentioned the Amish, or companies that don't want to sell pork for religious reasons, why haven't we talked more about those cases and how such employers are protected and their religious freedoms are protected, but when it comes to people who have any kind of a moral objection to contraceptives, any kind of abortifacient, why that is not seen as the same?
Greg, do you want to start?
Yeah, on the first point about how do we make it clear to the public that the government is requiring us to do something, I think we need to be careful not to embrace the government's misleading language. It's funny, they don't even say accommodation anymore. They call it an opt-out, which is utterly and terribly false. We are not exaggerating or misstating things at all when we say that the government is giving people two choices. Comply this way, way A, or way B, comply this other way. That's the choice that we have. And both of those choices involve us. It's a hijacking of our health plans. It's our plan infrastructure. And the things that we're required to do, communicate with our third-party administrators or insurers, are the things that are necessary as a matter of causation to cause these drugs to be provided. I think that we sometimes run into media that have embraced the government's narrative about this and have kind of mischaracterized what's actually going on. And so we do have this education process of telling people the way that we're involved, and it's not an exemption. There is a real exemption, and we don't get it. There is a compliance method B, and that's what we're forced to comply with. As far as like analogies to other circumstances, you know, we try. We certainly try. Helen just mentioned a case where a small religious sect was given essentially an exemption from the Controlled Substances Act in order to take this hallucinogenic tea as a part of their religious ritual. 8 justices out of 8 said that that was okay. There was no sort of ideological distinction on that.
You mean the court can function with only 8 justices, Greg?
Well, that's a whole other question, but in that case it certainly did. 8 justices, left, right, center, you name it, came down on the side of religious freedom and gave an exemption to someone from a law that I think all of us would concede is important. It's important, the Controlled Substances Act. But, you know, I think it's tough to get people to move away from the specific facts. This is about sex, this is about contraception, this is about abortion, about which people are very, you know, emotionally invested, and put it on a level of principle that makes these comparisons. So it's a difficult task, but we've been trying.
Just real quick on your first point, I completely agree that language choice is so imperative. And I know on our broadcast specifically, anytime we're referencing this mandate, we always say the so-called accommodation. Because if we say anything other than that, we are just falling in line with the administration's narrative on this. And we just, and sometimes it gets so-called accommodation, it's more of a mouthful to say, but it's the truth, and we need to continue to do that every single time.
Catherine, on that point, is there an opportunity to sort of broaden this to other people when we point out religious objections in other contexts, for example, in the kosher context? And yet, is there also an obstacle in the studies that show that people are less religious, and that including younger people are less religious than they used to be?
To the first point, I think it's absolutely important to show that anytime one religious group is targeted, persecuted, that's important for every religious group. I know something on our broadcast. If there's a group of Sikhs that they feel like they are being persecuted, we highlight that. Our Protestant brothers and sisters. Anytime there is something that's seen as a violation of their faith, anytime they have to go against their conscience, we want to highlight that, because who's to say that just if one group is at threat, that puts everyone at jeopardy. In regards to the religious landscape today, I mean, you can break it down. What if there were to be a Republican administration that goes against atheist groups? You know, we would also say, you know, we need to speak up for the freedom of expression in every group.
Or mandate a gun mandate. Every employer has to buy their employees firearms for their personal protection.
Right.
I just had a thought I wanted to add to that. Before, you made mention of religious freedom being seen as special pleading. I think that's a really important point. And when one speaks regarding the defense of religious freedom, I think you also have to pair with it. This has been my predilection, and I think it's a good public speaking strategy about it as well. You have to pair it with exactly what it is that the religion wants to do. It's when you ask for religious freedom, and then that's the end of it, that, you know, it's like asking for free speech, and that's the end of it. Well, what about crying fire falsely in a crowded theater, right? What about, you know, harming people in some other way? I think when we talk about religious freedom now, and it's partly why it's been such a joy to work vis-a-vis the Little Sisters case, because you go, listen, we want religious freedom for that. We want the ability to continue to work on taking care of the poor elderly. Or in the case of your college, it would be the ability to work with, you know, a historic Protestant sect that has had a role in, you know, parts of our national history, right? So I really do think you have to put those two things together often, or else people will start listing the parade of horribles. Well, if I just give you religious freedom, the next thing you're going to be, you know, putting widows on funeral pyres and burning them. Well, no, that's where the balancing test comes in, right? That's where the government can show a compelling state interest and win and restrict the religious freedom. So I just think it's important to give people what they want to know and what they fear, and give them information about that.
I was just going to add a point about the balancing. Religious freedom cases are always about balancing, right? And I think we've gotten away from that. And folks on the other side of these issues used to be more reasonable about it. You know, pharmacist objects to filling prescriptions for Plan B. Does it not matter that there are 30 pharmacists within 5 miles willing to fill that prescription? I think it does. And that's sort of an element of the balancing. We need to get back to that.
Right here, Kimberly.
Hi, I'm Kimberly Robinson with Bloomberg BNA. Can you guys have touched on it a little bit, can you discuss what Scalia's passing means in these cases?
So the question was about Justice Scalia's passing. Greg, you want to start?
Well, I think the place most people start in thinking about the impact, potential impact of Justice Scalia's death is the Hobby Lobby case, which involved method 1 of compliance, and the court held by a vote of 5-4 that they were entitled, that they, Hobby Lobby and Conestoga Wood, were entitled to assert religious freedom claims, and in their instance, they were substantially burdened, and there was a less restrictive way for the government to pursue its objectives, so they won. The assumption is, I suppose, that the same 4 justices who voted against Hobby Lobby will necessarily vote against the nonprofit religious organizations that are before the court right now. Now, I don't think that that's a necessary assumption at all. I think I trust the justices to look at the value of the Hobby Lobby precedent, which actually did some significant things that are relevant to the arguments in this case. So I hold out some realistic hope that it won't just be a 4-4 vote that mimics the Hobby Lobby vote minus Justice Scalia. But let's suppose for a moment that is accurate, and you have and that Justice Kennedy and the other 3 judges sort of on the what is commonly referred to as the right end of the spectrum. I'm not sure I like that language, but you know what I'm talking about. That there's a 4-4 vote. What happens then? At that point, the court has 2 options, at least. These are the 2 that come to mind. One is the 4-4 vote decides the case. In other words, in that instance, the lower court's judgment is affirmed by an equally divided court. It's not a precedential decision, but it means that all those parties that were appealing to the Supreme Court lose, but it doesn't resolve the question. You would still have a circuit split.
Except the ones who won.
Except
Like some of the people who appealed won below and some lost. So the ones who,
well, all of the
appellants.
parties that are before the Supreme Court
Oh, right.
lost in the
Yes.
courts of appeals. That's what I'm saying. But the other thing that they could do, and this has been discussed, it's not novel to me, is that they could just hold the case and set it for re-argument at a later time when there are 9 justices. Now, we don't know when that's going to be. It might be some time from now, but that's the other alternative. In terms of like the contents of the arguments, I think the arguments are what they are, and I don't perceive any sort of radical changes that any of the advocates are making based on the composition of the court minus Justice Scalia.
and I think it's important to note that Roe versus Wade itself, which is probably recognized across the spectrum as one of the most controversial decisions in the last 50 years of the court, was brought to the court in 1970, not decided until 1973, partially because of 2 vacancies on the court in the meantime. So this is a case that's one of the most monumental cases in Supreme Court history. It sat there for almost 3 years. If Roe versus Wade can sit for 3 years because of vacancies and other holds, then cases, not just this one, that might have to sit until next year, if that's what the court decides, is not going to ultimately change the way that the court can operate.
We have time for one more question, and then you are more than free, of course, to talk to the panelists afterwards. I have 2 in the hand. Sorry.
Hi, I've enjoyed the talk so far. My name is Dr. Robert Sanka. My background, I'm retired now, I'm in clinical psychology and ethics. And most frequently you hear the discussion about contraception, et cetera, in the terms of being framed as a woman's issue. And I haven't had a significant amount, but to them they were significant, couples. It's more than a woman's issue, it's a couple's issue. It takes 2 people for contraception to take place. And frequently I work with husbands who feel compelled to back out of the argument because it's their wife's choice. It's theirs, you see what I'm saying? But it's a family decision. It has to be a family decision because in a number of cases, the contraception went awry and it rendered the woman infertile or incapable of bearing children in that way. Now, that affects both. You see what I'm saying? So I think that we would benefit by expanding and being more inclusive, not maybe to the same intensity on a tier basis, but at least more inclusive to expand the dialogue in a more meaningful way to all the parties that are going to be affected and not just, let's say, one party. Does that make sense?
Yeah, Helen, do you have a perspective on that?
Yeah, that's usually when I hear the subject of men and contraception brought up, it's Mother Jones did an incredibly good article on it a couple years ago. It's why the pharmaceutical companies tried to make it for men, but the men were like, I'm not dealing with these side effects, thank you, no, right? And yet women are dealing with lots of different side effects. For anybody who's wanted to look that up, there's 2 books that are so good. One is called Sweetening the Pill. I think Ricky Lake is making a documentary out of it. And the other one is called Love's Labor Lost, by a gender studies professor, I think, at NYU, regarding the fixation on women's sexuality and not thinking of the relationship. So there's a lot of places where this conversation is not as good as it could be for the couple, for the children. And I do think the conversation that we've had about sex, dating, marriage, romance, whatever in this has been particularly impoverished. And going back to Matt's first thing, it's been reduced to politics when really it's about psychological, sociological, and healthcare issues. So I would affirm that.